Hello, hello. If you are here for the webinar about children's protection planning, you're in the right place. And I just wanted to let you know that I can't really see who's who out there. And that's kind of a good thing since we're talking about something that's pretty sensitive. So unless you want to identify yourself, there's no need. We don't need to know your identity. This webinar is really for education and information purposes only. And just to set a little bit of boundaries on what we're doing here today, even though I am an attorney, this webinar is not intended to give you personal advice or counsel. You may actually want to get your own lawyer to analyze your situation and apply law to your facts. So at this webinar, we can answer hypothetical questions, but we prefer that you not ask personal questions about your unique circumstances. We'll try to cover things fairly broadly. And if you do have a question you want to ask, frame it in the form of a hypothetical. I am going to turn the chat off until a bit later so that I'm not distracted because it chimes in and will derail my train of thought. So I wanted to welcome you to the first webinar for the Children's Emergency Response Plan. Now, I've been delivering this content for years now. This is the first time I'm delivering it in the context of a fully fleshed out, direct-to-consumer legal self-help product that we are offering finally to all parents in America. I've been able to have the honor of doing this planning for hundreds of families in my practice, and only recently have we been able to figure out how to bring this to everyone. So welcome to the first of these webinars. We will do them regularly so that people can really understand this content. You may even want to come back more than once if you're really curious about how this works and the moving parts of your legal life. This is a good way to understand that. So we're going to go ahead and get started. And I'm going to share my screen with you. There we go. All right, here we go. What I'm about to cover is not taught in any course. It's not taught in high school. It's not taught in college. It's certainly not taught at birth classes, and only occasionally at parenting classes at which a lawyer like me might present this content. Interestingly enough, there are only about 750 lawyers in the entire country who are very familiar with this concept of children's emergency response planning. And I know that number because I've trained about half of them personally. And that is of a population of about 30 to 50,000 estate planning attorneys in the country. So you can see that finding an attorney who truly understands the legal landscape here for parents whose children are still at home is a little bit like looking for a needle in a haystack. And there's a couple of reasons for that, and I'll just give you a little bit of background. One is that the estate planning arena has been dominated by older practitioners who are serving an older market. That's pretty intuitive. We know that our parents are more likely to do their estate planning than we are to do our own. But with the advent of technology, making estate planning less expensive and more accessible to families, and with families waiting longer to have their children, needing more financial planning to be done for them, the market has shifted towards a younger market. So our practices haven't quite caught up with old practices that have been in place for 150 to 250 years, but now they are. And fortunately, the Children's Emergency Response Plan is right on the cutting edge of that, of those changes. So welcome, and I'm very glad that you're here to find out what you need to know about how to protect your children in the event of an emergency. So types of things that we're going to cover today. We're gonna take up the question of what happens if something happens to you. It's uncomfortable, we know, but we're gonna dive in and do it anyways. We're gonna talk about the legal principles and issues that you have to understand quite clearly in order to make good decisions for your family. We're gonna talk about the flow of custody from you to who else, if you are unable to act as your child's legal caregiver, what your options are. We'll also talk to you about how our program works, the Children's Emergency Response Plan, and how the alerts that we have created for this program helps to keep your children safe. And also we'll talk about what a children's emergency response can't do and how to move forward. So the main question when people come and see me as a lawyer or come to see me speak at webinars and workshops and other speaking engagements, they really just want to understand what happens to the children if something happens to them. And everyone experiences it as a very intense, uncomfortable thought. And I feel the same way about it. So just know that I'm with you as well. Hold on just a second. Okay. It's just as uncomfortable for me too. When I was a new mom with my little babies, it was tremendously difficult to picture the world with my children in it and me out of it. So intense that I almost couldn't bring myself to deal with my own planning. Fortunately for me at the time, my ex-husband had a great deal of presence of mind. He's quite the doer, and he insisted that we get our estate planning in place. We had a pretty poor experience of it the first time we did it. We had a good experience the second time we did it. And when I ultimately decided to do this work as an estate planning attorney, those experiences of working with attorneys were quite informative to help me to figure out how I wanted to talk to parents, how I wanted to deliver legal services to them, and really help them understand some of these legal principles that are just not taught. So my experience as a consumer has informed how I discuss legal planning with parents. And also, there's, just so you know, there isn't a real strong keyword search. If you're on the internet and you're trying to figure out what good planning is for you as a parent, there's just not a good search term. You might try guardianship nomination for kids, but no one out there is teaching the depth and advanced level of planning that we teach here. So there's 3 things that you must know right out of the gate. The first thing is the types of custody. There are 3 different types of custody that you have to be aware of, and they each come with different levels of care that you must take around them. The first one is actual custody. That's the person who's holding your child's hand while crossing the street. That is your child's teacher if they are shepherding them from one place to another. That may be a teaching assistant or a substitute, or anybody at your children's school or daycare who is actually moving a child from one place to another. The next is called physical custody, also known as physical care. This is what you deposit into the possession of another person when you leave your child with them. So this is a little bit crude, but it's when you leave your coat at a coat rack someplace, you still own the coat, but you have left it in the care of another person. When you leave your children in the care of a daycare provider, they only have the physical custody of your child, and it has very little legal impact on your child or on you. You're just giving them temporary authority of your child to just take care of their body until you come back. They have no legal decision-making power as a physical custodian at all. This is really important for you to understand. Physical custody is just the base level of you know, moving your child around, making sure they don't get hurt, keeping them safe, keeping them fed, that kind of thing. Legal decision-making, legal custody, is the custodial issue that we have to take care of when we're talking about our children's legal care. That's the concept and the rights and responsibilities you take with you wherever you go. They do not leave you just because you've left your child in the care of a daycare worker or a school or anywhere else. You are still your child's legal decision maker, even in your absence. You can only transfer this custody through a conscious effort on your part. And this is the part that's very important for you to make sure that you pass on. So if we tee up the idea of you leaving your child with someone else, and you are unable to make it back to your children, what principles are at play? So let's just pretend that you and your partner, your spouse, husband, wife, have gone out on a date on a Saturday night, and you've left your children in the care of a babysitter. And something happens and you don't make it home. So what's happening here? What exactly is going on? Well, obviously, if you're in an accident, and that's what it's going to have to be, there's an accident or some kind of a tragedy involving you, the first responders on the scene are going to be police, fire, sheriff, paramedics, and EMTs. Those personnel, their first order of business is to secure you and your safety, to stabilize your health, to rescue you, whatever they have to do. If there is an accident and you have the indicia of child rearing, say your car seats or a diaper bag or kid types of snacks, and they're in the backseat of your car, those pieces offers notice to those first responders that you have minor children that you're taking care of and that you have constitutional rights over. It actually puts them on notice. And the term on notice is important because that alerts them that it is then their responsibility to act for your children. If there's an accident and you're not going to make it home, police are going to look at your last registered address. They're going to run your license and your registration and send a squad car out to your home and to see if they can locate the children. If the children aren't there, they're going to knock on some doors, the neighbors probably, try to find your children. The other piece that could happen is when you don't arrive home at the time that you say you're going to come home, your babysitter or caregiver may panic and may actually call 911 themselves. They might call neighbors. They might call hospitals. They might call their own parents if they're underage and need assistance. If you've left a number behind, hopefully they'll call that number. That would be ideal. If they can't reach you, then they'll try to reach out and find somebody to help them with your children. In any case, there's going to be a uniformed officer coming to the door of your home, knocking on the door. And the very first question that they will ask is, how are the children? Please let me see the children so I can check on their welfare. That's called a well child check. And that is a perfectly acceptable and good thing that police and sheriff do to check on the welfare of your children. They're supposed to do that. The next question they're going to ask is, do you have any right to hang on to these children? And the person who answers the door might well say, I don't know, do I? You tell me. Well, police and sheriff are permitted to leave children in the physical custody of a family member only. So remember that word physical custody that we brought up before, physical custody. Police and sheriff are allowed to leave children in the physical custody of a relative to that child. They're not allowed to leave a child in the physical custody of anybody else. They're just not. And because of that, they may take your child into their physical custody and take them down to the police station or find some way to care for your child. But they will not leave your children in the care of a babysitter who's underage. They will not leave your children in the care of a person at school or daycare because they have to close and go home. So they'll take your children into their custody. Under what doctrine does that happen? This is very, very important. This is called the Parens Patriae doctrine. The Parens Patriae doctrine exists as part of the fabric of our legal structure. There is no statute on it. It just exists. And this is what they don't teach you in school. Parens Patriae means parent of the nation. Actually, it's called father of the country, but to be more politically correct, we'll say parent of the nation. Parens Patriae power is the doctrine under which the government is the next in line in authority over your children. Not your family, not your children's grandparents, not your brothers and sisters or their aunts and uncles, not their cousins, and certainly not their godparents. None of those people are the next in line of authority over your children. It is the state. So who does that show up as? It shows up as police, sheriff, child protective services, and any other agency that might be on the scene who could be tasked with or empowered by statute to be the next in line of authority over your children. Many times I hear parents, when I tell them that, are a little bit aghast and uncertain about what that means exactly to them. And what it means is that when you leave your children in the care of one of your own parents, that does not necessarily solve all of your legal custodian problems, because your parents are not the next in line of legal authority. They may be allowed to take physical custody of your children, but you have to know that legal custody has already transferred to the state as soon as you are unable to respond to your children. There's nothing you have to do to make that happen. The state automatically becomes the caregiver for your children and the decision maker for your children. And that means that the police officer has the authority to remove your children from their home if they feel the need to. There was a story of a gentleman in Georgia last Halloween, and it's ironic that we're on Halloween and I'm talking about this again. 1 year ago on Halloween, a family in Georgia experienced a terrible tragedy, and you can Google this on your own. But a set of parents had gone out to buy face paint to finish their children's costumes and left their children with their oldest child, who was like 13 or 14, and they didn't make it home, the parents. And a state trooper in Georgia knocked on the door. He was the one given the job to go check on go find children. And he found this family's children with the oldest child in charge, which is fine. That wasn't an issue. But there's no way he was able to leave the children there. When they did locate the next of kin, which is also what they're supposed to do, the next of kin was 7 hours away. And this state trooper had the presence of mind to realize that it would be terrible, a terrible, terrible, horrible, awful experience for these children to be taken to the police station. And he contacted his superior officer and was given permission to take the children to dinner. So rather than taking them to the police station, the cop took them out of the home and took them to dinner and tried to keep them occupied while their grandmother was driving fast and furious back to the children to let them know what had happened to their parents. And apparently the neighborhood gathered together with the state trooper, who were able to bring candy to the kids, but they certainly were not with a loved one. They were with the state trooper, who did his very best to care for these kids. And he what a tremendous state trooper he is. And I have a great deal of respect for his presence of mind of understanding that going to the police station would have been a terrifying experience for these children. So that's a year ago today, and we can do better. We can help these the police and sheriff, state troopers do a better job by making sure that we have appointed legal caregivers for our children. And you know how you can do that? Because you have the constitutional right to do that. You have the power to transfer legal custody of your children to someone that your children know, love, and trust, so that they are immediately available, immediately empowered to take legal custody of your children, and then the state doesn't have to act. The only reason the state has to act is because we fail to transfer the legal custody of our children seamlessly and easily, which is why we've created this product. It's the very first time that you've been able to do it from the comfort of your own home, creating legal documents without even having to leave your desk. So just to recap a little bit of the legal flow of custody. And this is an infographic you can find on our website, gochirp.com, and that's C-H-E-R-P, gochirp.com. You can find this infographic under, I believe it's the first tab in the navigation bar at the top. So you should get familiar with the flow of custody. So if if you are married or you're co-parenting with your child's other parent, you need to know that legal custody transfers automatically from one parent to another because you share custody. You don't actually have to do anything to make sure that your child's other parent is empowered to take custody of your children in an emergency if they are on scene. So we want to make on scene or on site or nearby. So if they're out of town, we actually do want to back up for our own children's other parent. That includes 3 or 4 people in your local base of operation. And as you can see by this infographic, what happens if something happens to both of you or you are both unavailable to respond to your children? Well, you can see by the infographic that the state becomes the caretaker, the next in line in legal authority over your children. And that's not your family. But that you can bypass that flow of legal custody by authorizing temporary parental delegates to take legal custody of your children if you can. We have to do this in writing. We want to make it an official signed writing. And that's because while you might be able to do it in a handwritten form, it's so much better when police and child protective services and law enforcement who are tasked with carrying out your wishes see an official signed writing. They can take it seriously. They know you meant what you were doing. They know you took the time and the effort to think through your issues of who was going to take custody. And it's just so much easier when you make things official and look official. So what are your options in this flow of legal custody? What decisions can you make? Well, you can do nothing. And most, in fact, almost all parents, something like 76% of parents do nothing and rely on the beneficence of government to take care of their children. My husband the other day was remarking to me like, wow, we wouldn't trust the government with our like vintage cars or our homes. Why on earth would we trust the government with our children, our most precious beings, the ones that we love the most? Why would we ever allow government agencies to take custody of our children? Even as well-meaning, well-trained as government officials are, the system is incredibly flawed. And it's not something that we should lightly allow our children to enter into, especially since we have the power to bypass that system. So your other option is that you could write up your own documents, write up your own plans, and hope that you did it right. And that, no one can really help you with that. And certainly nobody could give you legal advice. I see a lot of people who are trying to find easy ways out of doing legal planning entirely. And sometimes we'll get calls from people saying, hey, I got these forms online. Would you review them for me? And the answer has to be from any reasonable lawyer. No, we can't do that. We can't accept the liability for something that we don't know is done well and as well as can be expected. So don't expect a lawyer to help you in that way. But since a lot of families are just unwilling to engage in a relationship with a lawyer, we figured out a way to bring this type of planning to you without having to have legal support unless you have an unusual situation, which can happen. The Children's Emergency Response Plan is the first time where you can create a fully thought out legal plan for your children without having to hire an attorney. Now, you may want to hire an attorney later for sort of the asset transference aspects of estate planning. That's always a good idea. It's always a good idea to have a lawyer on your side, in your corner, to help you and advise you. And you would really want to have your own children's emergency response planning in place, since the vast majority of attorneys don't really know or understand how to do this planning anyways. So bring this plan to them and say, I'd like to do my estate plan now. I have a children's emergency response plan in place. I've done the first part of my job, and I need help with the remaining financial aspects of my estate planning. So you can get your own children's emergency response plan in place before you ever see a lawyer. And that's okay. So how does the Children's Emergency Response Plan work? Well, it helps the system help you by making sure that you have signed, notarized, and witnessed documents in the right hands at the right time so that first responders can defer to the people that you have set up as your agents. And this helps you to assert your constitutional rights as a parent. So by the way, your constitutional right as a parent is, we can actually verbalize it. You know, I think you probably know you have some kind of rights as a parent, but what are they? A case in 2000 was the case that gave us words for it, and it's called Troxel v. Granville, if you want to look it up. And Troxel v. Granville states that a fit parent has the fundamental right to the care, custody, and control of their children, and that right cannot be modified or interfered with except to vindicate a compelling state interest. And any rules or regulations that is in service to a compelling state interest have to be very narrowly tailored to only vindicate that compelling state interest. We usually see states intervening in the functioning of a family in a couple of ways. One is obviously education. We need our children to be educated in order to have a functioning society. And healthcare, most notably failure to provide healthcare, and also vaccinations is where the state has taken a pretty firm interest in our children's care. So that's where you'll see most state intervention in those two arenas. And very little intervention in this arena where a parent has the right to determine who will follow, who will be our successors, who will take care of our children, who will receive them into their home, and how. Very little state intervention in this arena, and we wouldn't want that anyways. So some folks don't quite believe that children's emergency response planning can help them in any material way. So if that's you, these are the most common responses I get from people, and that is, I already have a will. I hear that a lot. I already have a will. I have a will. So I've done it. Well, a will is not sufficient planning. This is the old school style of planning that you'll hear a lot of estate planners say, oh, that's all you need to do. That's actually not true. A will is insufficient. A will itself, where it contains a nomination of guardianship, is not sufficient. And the reason is that a will is a dead document until we die. It is dormant. It has no legal effect until we have actually passed away. And that document has been submitted to a probate court, a probate opened, and the probate judge has affirmed your nominee. What happens if you're not dead? What if you're just delayed, or you're stuck in another country, or you're in a coma? There are a lot of things that can happen now that are short of death, in which case your nomination of guardianship isn't going to even work. So we need to have these documents outside of a will as separate freestanding documents. Additionally, wills don't deal with the short-term issues, the issues of being incapacitated or dying, and what happens in the immediate moments or hours after that happens. A children's emergency response plan is designed to deal with the short-term as well as the long-term issues. Many parents think that they just don't need a special plan that's just for their children, and that's actually not the case. We do need a custodial plan for our children's legal care in addition to a regular estate plan. I frequently hear a response of like, my mom has got my kids, so won't the authorities just leave my children in my mom's care? This is very, very important. Yes, authorities such as police and sheriff will very likely leave your children in the physical care of your mom or your father or another blood relative who's there, but that's not their legal custody. So I have heard stories of where a parent has not returned home and the child was left in the physical care of a family member. But you have to understand that a caseworker from Child Protective Services has already been assigned to that child, and that person is the decision maker for the child's care. They may be cooperating with family members to determine where the child will sleep at night, where the child is going to stay while the child's legal custody is being worked out. But you need to understand that the caseworker there, as the expression of the state, is the decision maker for the child's legal purposes, for all the child's legal decisions. And they will consult a court when they need to, or when their own regulations require that they consult the court. So I hope that makes sense. Even though your children may be in the physical care of a family member, the legal decision maker has already become the state. But we can bypass that by transferring legal custody in writing to our short-term or temporary parental delegates when we do it in writing. And I often hear people say, oh, I'm not worried about it. It's not going to happen to me. Great. I don't think it's going to happen to you either. And to that degree, a children's emergency response plan is an insurance product. It is a just in case. And there, I don't know if you can hear it in the background, there's an ambulance siren going by me right now. It won't happen to me. We hope it doesn't. We hope it doesn't happen to most people, but we also know it's going to happen to some. And to bring this point home to my husband and I, who we are working on this together, just a couple of months ago, our two seniors in high school lost their AP physics teacher in a tragic accident where he and his wife were both killed, leaving their 2-year-old daughter behind. So it does happen. And it could happen to me. One of the strange pieces of doing this work is that it almost does feel like flirting with death a little bit. There's a little bit of jinxing. People feel like maybe they're jinxing themselves if they take care of this planning, if they're calling it in by paying attention to it. And I'm here to tell you that some people are going to die. There are going to be a number of parents who don't make it to their children's growing up years. And in fact, it turns out that, I think it was New York Life did a study on this, that 1 in 9 children will lose at least one parent by the time that they turn 20. And 12 children out of 1,000 will lose both parents by the time they're 20. It's somewhere in their growing up years they will lose both. That was way more than I thought it would be. When I saw that, I was just astounded. Tragedy hasn't struck anyone in my immediate family like this, but it certainly has struck some of my extended family, actually quite a few times. I have a very large family, so out there it has happened a number of times. And I'm knocking on wood, and I'm a lawyer. So I hope it doesn't happen to you. And this is not going to jinx you to take care of this. In fact, I have a belief that taking care of this helps us stand up nice and tall and take control of our lives and not shrink in the face of fear of our own mortality. So if that's you, more power to you. I do hope that you take advantage of this offering. The Children's Emergency Response Plan also has a set of alerts that are really important to help first responders know what to do when they are working on you. So of course, recalling the visual of you being in an accident, first responders are on the scene, they're stabilizing you, working on you, trying to save your life. And when they're also trying to figure out where your children are, let's make it really obvious for them. So we do that. One way is through a squawk screen, we call it. A squawk is an alert that goes out that says something has happened to you. And we start that process by notifying first responders that you have a plan in place. And one of the things that we provide you as part of the plan is a lock screen alert system. So when you open up your phone, when a first responder picks up your phone, the very first thing they see is a squawk screen that says, in case of an emergency, please contact. It says Children's Emergency Response Plan on it. And I'm looking at my squawk screen right now, and it has my husband's name, it has my oldest son's name, and 2 of my dearest friends' names and numbers on there. So if something happens to me, a police or EMT know exactly who to call. The next is that we have a customized wallet and glove box instruction cards. We want to make sure that your wallet has a very obvious, in case of an emergency, card in there to let first responders know who to call when they can't, when you won't be able to return. We also have window cling stickers that we put on the back window of your automobile that says, I have a children's emergency response plan. See my glove box for instructions. So of course we don't want to have any personal information out in the world for all to see, but we can certainly put it in your glove box. So we have printed instructions of who to call in case of an emergency right in your glove box. And then we also need to make sure that your babysitters are informed about who to call in case of an emergency and how to handle an emergency. Most of us will leave the home with leaving our children in the care of someone, and we'll give them a cell phone number and say, hey, well, we're going to such and such a place, and we're back at such and such a time, and here's our cell phone numbers, and then we leave. Well, we need to do a little bit more work than that. We actually need to let our sitters know that if you have an emergency with our children, of course, call 911. If there's an emergency with you, yes, of course, call 911. But if we don't return home, don't call 911. You don't need to do that. We want you to call our first responders and get them together with our children before you call police or 911. Make sure that our children are safely in the care of one of our legal delegates so that our children aren't taken into protective custody or run the risk of spending any time at all in foster care. Okay. So what can a CHIRP not do? This is really important. A CHIRP cannot alter parents' fundamental rights to their own children. We cannot interfere with or alter the fundamental rights of a parent who is still wielding their parental rights. I have received plenty of inquiries from both moms and dads who would love nothing better than to eliminate their children's other parent from the picture. We can't do that. That's only court can do that over our children. So just know that CHIRP cannot be used in that way and will not be permitted to be used in that way. And when you sign the terms and conditions, it actually has you affirm that that's something you're not trying to do. If you have that kind of a need, you must get a separate attorney to deal with your custodial issues. On the same note, actually, you can't give back to a parent their fundamental rights if they've been restricted by a court. I've received inquiries on that too. Well, situation where for instance, this is a hypothetical, like a parent has healed and gotten all their ducks in a row from, say, an addiction or some kind of behavior that's not healthy, but they're healthy, and the other parent wants to give parental rights to that previously restricted parent. We can't alter that, so only a court can do that. Also, we can't really completely eliminate the state's interest in our children. A court always has jurisdiction over our children's welfare, and if something is going awry, they're always going to be able to intervene. But what we are doing is asserting your fundamental rights at the highest level so that the decision, you remain the decision maker for your children even when you can't speak. And only if your children are endangered or only if there's something really going wrong can a court intervene and alter the plan that you've set in place. And even then, if your children are in the care of someone who's not doing well, a court's going to go back to your original plan and move down the line of your delegates or your guardians to your second or your third nominee. So they won't just go off the script. They'll have to abide by the terms of your plan, even if something is going wrong. The other thing is that CHIRP is not a full estate plan. It does not help to move your money or your assets around easily and seamlessly if something happens to you through death or disability. Only a real, fully fleshed out estate plan can do that, and I really urge you to do that. Get started on your estate plan. Getting that done is such a relief, and having an attorney that knows what they're doing is also, it's such a gift when you have an attorney who can explain to you all the different things that you need to take into account, at least financially, for your family as well. Okay, so next steps. That sort of wraps up the body of our presentation here, and just to take a little bit of time on what you can do now that you know you need some kind of planning in place. Have the conversation with your partner. If you have a partner and you share custody of your children, you should determine who you will empower to act for you on a temporary basis and also on a permanent basis. So that's the next 2 bullets. Decide on 3 or 4 local temporary parental delegates who can care for your kids. And these are, don't overthink this. This should be relatively easy. We're looking for people that you trust, that your children know, love, and trust. Because these are the people who are going to wrap their loving arms around your children in an emergency and take care of them. They're going to break very difficult news to them if they're old enough to understand. And they will relinquish that custodial job to your permanent guardians when they arrive or to you when you return. So don't overthink it. Just make it 3 or 4 local people that you trust and that your children trust. The next point is actually more difficult for many families, and this is deciding who would raise your children if you can't. We are looking for 3 or 4 people that you would consider appropriate long-term placements for your children. This is where a lot of people stop. A lot of people just get tripped up here, and I really want to encourage you not to stop just because this is difficult. Because when you fail to make this decision, you are leaving it in the hands of the government to make the decision for you. And the government, which shows up as judges in your district, they don't know your family like you do. They're just doing their best. They can't tell. They can't tell one sibling might have a drinking problem. They might not be able to know that another person in your family has a history of violence or is just really not a good fit for your kids or your family's philosophy. You have got to make this decision, even though it's difficult. And if you are on this webinar, we will provide to you as a bonus gift how to decide on how to choose your guardian matrix. So we have laid out for you the most common factors to take into account in deciding who will raise your children and the really easy visual way to make that decision. I also encourage you to make the decision because you can change your mind. We make this system so easy to use and so inexpensive that you could literally change your mind the next day after you have made your nomination, and you can redo it. And the reason we do that is we don't want you to feel like this is something you're chiseling in stone. You're not. It's like you are etching it in sand, and only after something happens to you does it set into like concrete. Up until that happens, you can change it at a moment's notice. And you should change it. You probably will change your guardianship nomination 2 to 3 times while your children are growing up. So get used to the fact that you just need to stay on top of this. And that we have made it easy and inexpensive for you to do that. Okay. All right, so that's it. It's about 43 minutes in. And you can, if you need some guidance on this, I will be online on the CHIRP Facebook page on Friday afternoons at 4 o'clock Mountain Time for about a half an hour to answer questions. So I'll be there this coming Friday, 4 o'clock, on our CHIRP web Facebook page. So you can go like that page and get an alert about that. I'll just be on for about 30 minutes if you need some one-on-one care. And you can also email us at hello@gochirp.com, and we'd love to hear from you. In conclusion, you are it. You are your child's best and only advocate. You are your child's only legal caregiver. If you don't do this, the only other entity that can is a court. And if you don't want a court to make decisions for your family, then you have to do it. You have to make these decisions for your kids. And I know how scary it is and how unnerving. And I still encourage you to do it. So this is Martha from CHIRP, the Children's Emergency Response Plan. I'm the CEO. I'm also an attorney and have my own firm in Boulder, Colorado called Hartney Law. And you can see me there as well if you'd like to know more about our legal planning for Colorado families. And I thank you for your time and your attention, and good luck.